this is applied to Mr. Jones' case, that leads us to the resentencing here today pursuant to statute. The maximum term that is to be considered by the court is 60 years. I don't have discretion with that. Everybody agrees that's going to be the maximum term. The question is what should the minimum term of imprisonment be for Mr. Jones in his circumstance? Certainly the sentence does need to be proportionate. That means to me that you need to take into account peculiarities and specifics about the offense itself, and I need to look at those same things, individual characteristics and things about the offender, and then balance those things in an attempt to come to a reasonable sentence. Certainly there is no rigid mathematical formula that can dictate a sentence. I do recognize that criminal sentences generally try to achieve 5 goals: societal retribution, prevention of further criminal acts through incapacitation and deterrence of further crimes, rehabilitation of the offender, and victim restoration. And this court has concentrated on these things when trying to decide what sentence to impose here. Before the court is a gentleman who has spent his entire adult life in prison for the crime that was committed. And I do take into account that he's just as culpable as an aider and abettor as the principal here. At the time that the crime was committed, the defendant had no criminal history. I look at what he's done in the prison system. I look at the support system that he has in place. I certainly take into account, and I firmly believe, that Mr. Hermanns' family received justice when the sentence was imposed, the conviction was received during the proceedings in the late 1970s and 1979. But Mr. Hermanns' family deserves continuing justice, certainly. When I apply the Supreme Court cases and the statutes in the state of Michigan, as I've sworn to do, Mr. Jones also deserves justice, and I think the Supreme Court cases and the legislature have, through the case law and the codification of the law, have basically told people that young people are capable of redemption. And the state, at the federal level and the state level, recognize the capability of redemption and how that should be applied on a case-by-case basis by people like me sitting and judging the facts of a particular case. As I've said, that's what I've sworn to do, is to uphold the law, and that's when I read these Supreme Court cases and I read the legislative history, I read the statute itself, that's what it tells me. I need to balance out, in short, Mr. Hermanns' family's need for justice, and they're deserving of justice, and applying the concept that the possibility of redemption exists for individual defendants who commit awful acts when they are young. When I do that in this case, I find that a proportionate sentence in this file is one of not more than 60 years and not less than 30 years. Mr. Jones has credit for 13,907 days already served, and that will be applied as credit. I come to that number in a variety of ways, but I think, to put it succinctly, the principal in this matter received a sentence of 30 years on the minimum, and the principles of the aider and abettor theory is, again, that the aider and abettor is just as culpable as the principal. If that's what the principal got, I think that it's proportionate to give the aider and abettor the same. So the sentence for Mr. Jones will be 30 years to 60 years with credit for all the time that he has served.